What is use in commerce for a trademark? So you can only get a trademark registered at the USPTO if, in the United States anyway, at the USPTO, if you are using it as a trademark in commerce. So all three of those terms have, of course, a legal definition, but let me just break it down for you. So for one thing, you have to be using it as a trademark. Using it as a trademark means using it in a way that would be recognized by someone as a brand, not using it as your company name, not using it as your URL, not using it on a, well, maybe on a business card, but not using it in a way that just looks like the name of a company. So as an example, I have a package here of Sun Chips. If you can see where it says Frito-Lay there on the back, where is it there? That would not be considered trademark use. That is just saying, you have to put the name of the company on the label. That's what that is. That is not trademark use. As opposed to Sun Chips, which clearly is trademark use. I would say it's pretty obvious. It's a brand. It's big on the package. It's got a logo, and I'm also going to point you out to this little thing here, Smart Label. That also sort of looks like trademark use to me, right? You see how it's a logo. There's a and it's not something that's in the package. It has to do with the label. It's someone else's trademark that's being licensed for this. That's a whole other video. But the point being that Sun Chips is being used as a trademark on this, and Frito-Lay is not being used. Where is it? There, as a trademark on this, okay? So that's one thing. Just because it appears on your package doesn't mean it's automatically going to be seen as trademark use. In order to actually support a trademark, it needs to be used as a trademark in commerce. Let's talk about that one. This was something I bought out of a vending machine. That is use in commerce. This is something that I actually, as a customer, was able to buy. If this hadn't been sold, offered for sale yet, if they weren't available, it was just sort of pre-orders, or this is what the package is going to look like before it gets printed, that is not use in commerce. It's also use that hasn't started yet. That's the point. The date that you have to say when it was in use. It's not actually in use yet until it's actually offered for sale. So for sale or for distribution, if your thing is free, that could still be use in commerce. We'd have to talk about what the commerce part is, but it's a little bit flexible on that. It doesn't necessarily have to be something that someone buys. But it does have to be public. It cannot be sitting, in a website that hasn't been launched yet. That does not count as use in commerce. So that's really the main points I wanted to make there. And the other thing to keep in mind, so you can file an application to register a trademark before you're using it in commerce. It's a good idea to do that because you can get through the very time-consuming, you can get your priority in the United States and get through the time-consuming process of the trademark office before you're actually using it, and that way you're going to be laying out some money to get marketing and packaging and stuff done, and that way you'll be able to better protect yourself from, to be able to actually use that trademark and not have someone beat you to it. Remember that trademarks are first come, first served. Whoever's first is the one who gets the trademark. It doesn't matter who made it up. What matters is who got it first, who put it into use or filed an application to register it first. Okay, so I hope that's clear and hope that was helpful. Catherine Cavella, IP Works Law. Thank you.